noise-making devices at this time? Thank you. All rise. The Arizona Court of Appeals, Division 1 is now in session.
Please be seated. This is the
They've done that for Randy.
Excuse us, we're having door issues.
This is the time scheduled for oral argument, and our appeal number is CV130130, Cancino versus Access et al. Each side has been allocated 20 minutes for oral argument. You should be aware that we have read the briefs, we've reviewed the record, we have conferenced this case. So we're well aware of what the facts and the legal issues are and the issues presented to us. So guide yourself accordingly in your oral argument. You have 20 minutes each side. If you don't need all of it, don't feel you have to use all of it. Just once you're done, sit down. You'll also note that you should be aware that we are both audio recording and video recording this argument. So when you approach the podium, please clearly state your name and who you're representing for the record, for that informal record. With that, counsel for the appellant.
Thank you. Good morning, Your Honors. My name's Jake Hecker. I'm with the firm Stenson Leonard Street and represent the appellant Deanna Cancino. I would like to reserve 5 minutes of my time for rebuttal. We're here simply asking that this court overturn the ALJ, or excuse me, the director designee Todd Jansen's decision reinstating Dorinda Lang's recommended decision and thereby also overturning the state court's ruling upholding Director Jansen's decision. The relief requested is simply to compel MHCG to provide what is now retroactive coverage for Remicade to treat her severe Crohn's and ulcerative colitis. As Your Honors are probably aware, supplemental briefing was submitted within the last few days, and the statute that we're fighting about right now no longer applies. However, that being said, our client certainly covered what we consider to be substantial expenses out of her pocket since the denial that we feel was wrongly issued, and we're seeking basically reimbursement for those out-of-pocket expenses.
Is there any fund to reimburse your client with? If we were going to reverse, is there any fund or entity that could pay your client that money?
Your Honor, I'm not aware of any specific fund that's been set up or designated, I can certainly, look into that issue. We would suggest that that money should come straight out of MHCG's pocket, since they've been aware of this issue for quite some time.
Mercy HCG,
I'm sorry, Mercy Healthcare Group.
yeah, I know that, but I mean, does it still exist
I
as an entity? Or is it it's one of its parent or umbrella entities that might be a,
Again, since January 1st, I haven't looked into that issue. I certainly could. To my understanding, it's still a viable functioning entity.
if we affirmed, then that damage claim would be gone, right?
The damage,
The
yes,
Reimbursement claim.
yes, Your Honor.
Okay.
So, as you're well aware through the briefing and the extensive record, we feel that the director, Mr. Jansen's decision is both not justified by the evidence as well as contrary to the law. We feel like the upholding of that decision was an abuse of discretion for several reasons. The first is the formulary contained in the GSA, or Group Services Agreement, is a legally deficient formulary that runs contrary to the very statute that enabled this particular health care plan for small businesses to exist.
You're talking about subsection Q.
Yes, Your Honor.
But
Specific.
how does it violate, how is it inconsistent with Q?
Well, Q states that a health benefit plan may not deny, limit, or condition the coverage or benefits based on the person's health status-related factors. And we feel the key verbiage there is that it's coverage or benefits.
Well, okay, I don't disagree with you that we're dealing with the benefits. Let me put it this way. Let's talk about benefits, okay? Let's do that.
Certainly.
Let's go with benefits. What I did not see in looking at, well, let me start at the beginning. That sentence that you're focusing on is rather analogous to similar provisions in, I believe, Medicare and also some regulations that also are Medicare regulations. And also there are federal cases on this. And it is looking at whether a insurance carrier is denying benefits based on that individual's status. In other words, is the carrier discriminating against that individual because of their health-related condition or status? And here, the director determined that denied this drug, not because of anything unique to Ms. Cancino, but because the formulary didn't include the drug. So I'm having a hard time accepting the premise that this first sentence in Q is implicated here.
Certainly, Your Honor, and I would respond by saying that ties directly into the issue of medical necessity, and specifically whether a class or group of drugs, in this case the TNF-alpha inhibitors, of which Remicade, which our client takes, is a part of, is medically necessary for the subset of patients who can't be treated by any other pharmaceuticals or any other drugs that aren't in that specific TNF-alpha inhibitor class. And the medical necessity term is also hugely important, as you mentioned, in the federal Medicare and Medicaid cases and statutes that address this issue. And there's been briefing back and forth about whether medical necessity is important, whether it's not. We posit that it's absolutely important, and if it is determined that this class of drugs is medically necessary for our client, they can't exclude this entire class of drugs because they're impermissibly discriminating against a subset of individuals who have these diseases that can't be treated by any other drug on the formulary, if that makes any sense.
Doesn't that raise another issue or problem with that argument is that, and I mean, I've gone through the handbook and the plan and the contract and the statutes, and There's nothing more exciting than reading things like that in Medicare, and I don't mean to in any way be facetious, because this is a serious problem. But I did not see anything that specifically said medical necessity was a grounds for obtaining a benefit that is not included within the plan.
There's nothing that specifically states that bridge, but our client's position is simply that you can't deny benefits based on health status related factors. Health status related factors is defined to include health status or medical conditions. Medical conditions are the Crohn's and ulcerative colitis, and if those things can't be treated by anything on the formulary, then it ties back into the statute that you can't deny benefits based on that health status related factor, i.e. the extreme manifestation of these particular diseases in this subset of patients.
But isn't all that, I'm not sure you judge, but isn't all that circular? I mean, in essence, yes, if Mercy Healthcare had said, healthcare group had said, we're not going to provide you, Ms. Cancino, with these benefits because of your health status, but other people we might, then you might have an argument under Q. But because under the regulations, it all, and under the cases that Judge Norris was discussing, it's all, well, we're taking this individual and saying, no, while we would provide it, we're not providing it to you on your health status, based on your health status. And nothing, and the reason I say it's circular is because you're saying, well, there's no medical necessity requirement, but there should be under Medicare. But Medicare doesn't apply here.
Well,
There's no statute or regulation that says you have to have a medical necessity clause.
respectfully, Your Honor, I'd respond in two ways. First, to the latter point, if you look at MHCG's own definition of formulary found in the GSA at page 74, it's defined in pertinent part as approved pharmaceutical drugs to be prescribed to members when medically necessary. So their own formulary has a self-defined condition that these are drugs that are prescribed when medically necessary.
But that only means if it's on the formulary and it's medically necessary, we're going to give it to you. We're going to pay for it. It doesn't say if it's not on the formulary. As a matter of fact, the statute says if it's not on the formulary, you can't provide it.
Certainly a good point, Your Honor, and responding to that, Your Honor made a point that if MHCG had said, you, Deanna Cancino, we're going to deny benefits for, but for others, we're going to provide them for, related to these diseases, then we may have a point. I would respectfully respond that that is exactly what they did. They just didn't do it in those terms.
Did they provide the TNA alpha inhibitors? Is that what it's called? Excuse me. I'm doing
TNA
this from
alpha
memory.
inhibitors, yes.
Pretty good. I'm an old guy, and I could remember all that. That they provided those to other people in her condition?
They did not, and that's the key point, is that Deanna Cancino represents an entire subset of patients that can't be treated with the drugs on her formulary, and therefore they're denying a benefit they're providing benefits to people who don't have the extreme manifestations of these particular diseases. In their brief, I believe they listed some examples. I don't remember them off the top of my head, but they say our formulary does have prescription drugs to treat these diseases. We just don't include TNF-alpha inhibitors. Well, that's great, but they're providing a benefit to the people who don't have these severe manifestations, but they're denying that same benefit to the people who have that same medical condition only in a more extreme form. And that's how we view the health status related factor tying into medical necessity. And just closing the loop on the medical necessity point.
And, excuse me, what page of the GSA was that in? The 74?
The definition of formulary is on page 74, and the definition of medical necessity is on page 77. I believe that the initial GSA that was provided to the court was had those pages omitted, but I believe it's tab E, if memory serves me correct, in the reply brief. So when viewed in that light, we view that this particular formulary and the denial of benefits for the subset of patients with this particular manifestation, the extreme manifestation of these diseases, is discriminating in not providing a benefit based on a health status related factor, which is in direct contravention of the first sentence of subsection Q, which that statutory section is the very section that enabled this plan to exist. Opposing counsel pointed to the second sentence of subsection Q, which, if you'll give me one moment and indulge me, states a health benefit plan shall not provide or offer any service, benefit, or coverage that is not part of the health benefit plan contract. Well, that's all well and good, but that runs afoul of not only the first sentence, but it also violates the Equal Protection Clause of the Arizona Constitution.
Before you get to the constitutional argument, the first sentence was added in 2008. Is that correct?
I believe that's correct.
Did you do any research on what the source of that amendment was and how it related to HIPAA?
Your Honor, I did. I don't have that information in front of me, and just being frank, I can't respond to that. I do recall that the legislative history research that I did as to the second section, and that was actually cited in the response brief by the appellee, made a big deal out of the addition of the second sentence. However,
The first sentence.
actually, I believe it was the second sentence. The health benefit plan shall not provide any service, benefit, or coverage that's not in the plan contract.
I'm sorry, you're right. Okay.
And the key, again, there is that it's either or, benefit or coverage. And, you know, we're talking about benefits. The legislative history on that section was all within the realm of coverage.
But did you, let me rephrase, because I got confused. Let me reformulate my question. Did you do any legislative history research on the first sentence?
Again, the same answer.
And
I did.
The HIPAA, and that was related to HIPAA. And did you happen to notice that there was a federal regulation that dealt with this under the HIPAA as it relates to HIPAA and Medicare?
Well, there are several federal statutes that define a legally sufficient formulary. They require a formulary to cover drugs within each class of medications, and if that's what you're referring to,
No.
then
I was
certainly.
actually referring to one that talked about what the discrimination.
Oh, okay. I'm sorry, Your Honor, I don't have that off the top
Okay.
of my head.
Okay.
Let me see if I can articulate a question I have, and forgive me if I fumble a little bit. Based on the briefing and your argument today, what I see is a conflict that arises based on your argument between the first sentence of Q and the second sentence of Q. Because the first sentence says, thou shalt not discriminate based on a person's health status-related factors, which are further defined in the statute. And then the second sentence says, you can't offer anything that's not part of the plan. How do I then distinguish between a benefit that is deprived or denied, that the denial is discriminatory, versus a benefit that is not part of the plan? How do I, and that seems to me the problem with the argument that you're making today.
Well, and Your Honor,
You're setting up an inconsistency, and I'm not sure they're inconsistent.
well, I briefly mentioned this a few moments ago. The legislative history behind the second sentence that says you can't provide coverage or benefits outside of the plan was really added in the legislative history showed in the coverage context, meaning it was more of a coverage, not a benefit issue, which was the impetus for the addition of that sentence.
But aren't we limited to the plain language of what the statute says?
Well, we are, unless the statute is not only unconstitutional, but contravenes the entire purpose of the plan, which is to provide small businesses with health care that covers health status-related factors. And again, this all goes back to the key that I see is they're providing coverage for people with Crohn's and ulcerative colitis, just not the extreme manifestations. And that's the discriminatory impact.
Forgive me, this plan is a very limited plan.
It is.
There are many, many things that are excluded, explicitly excluded, that I think a lot of people would say, wow, that's really a shock. I think that would be something that really is medically necessary to treat a certain type of medical malady. So it's a very limited plan designed to focus on people with limited economic resources. So it may well be it doesn't cover everything. And isn't that really the essence of your argument, is that it should cover more than it does, and it just doesn't?
Well, I can see why Your Honor might view the argument that way, but that's not really our argument. Our argument is you can't deny based on health status-related factors. And if the plan says we exclude anyone who has leukemia, then anyone who has any manifestation of leukemia will not be covered under the plan. However, the plan does cover some prescription drugs to cover the particular diseases that afflict my client. And it just doesn't cover the ones that she needs. And so our argument isn't a broader scope of coverage. It's if you're going to cover X, you need to cover X all the way through, including the extreme manifestations of it.
That's the problem. That's not the purpose of that section. All the case law, a lot of the case law and the commentators and the federal regulations say it's aimed when you say it's aimed at an individual. We're going to cover everybody else, but not you individually for this condition. And that's the real problem. Otherwise, the plan would have to cover everyone for everything. In other words, someone comes in and says, well, gee, I've got first stage cancer. Well, we're going to cover certain things for first stage cancer, but we're not going to cover, let's say, more extreme services for stage 4 cancer. You'd say, well, no, you have to cover all types of cancer.
Under this
Otherwise, you're discriminating on basis. That's what your argument is, and then it makes the program unaffordable.
Well, under this plan, the way it was set up with that subsection Q and health status related factor kind of caveat, I mean, that's the argument. I'd like to...
I'm sorry. So you're saying that because of Q, the healthcare group plan would have to cover everything?
That's certainly not what I'm saying.
Okay.
Just in my particular client's position, we feel that they're violating that particular section. We feel that is unconstitutional to boot, and we feel like the ALJ or the director designee's decision was pretty much founded upon the medical necessity issue, and that issue should be moot because, as their own plan defines that term, he can't substitute his decision for that. That was her doctors that had to make that decision.
We don't get to the issue of medical necessity, whether it was actually medically necessary, if we're saying the plan doesn't cover for doesn't have to cover for medical necessity. We don't have to get into the issue of did she prove that this was medically necessary for her, right? If we're saying that you can exclude things, you don't have to have a medical necessity coverage, and it doesn't violate Q as a matter of law, then we don't have to get into the facts about whether she proved or didn't prove medical necessity.
Well, and it all goes back to the definition of health status-related factors and how you interpret that. I think I'm out of time.
Hold on one second.
Excuse me.
Why don't we add a minute on for rebuttal and but give 21 minutes to the appellee, so it's equal time. Okay?
Thank you, Your Honors.
Thank you.
As they say in soccer, it's overage time.
but no yellow card.
Good morning, Your Honors. Teresa Dwyer-Federhar, Fenimore Craig, on behalf of Mercy Healthcare Group. I have with me Ken Rudisall from Access, representing Access. He's ceded his time to me here today. The court should affirm the Superior Court judgment and the director's decision. This case is about what the statute means and what the contract says, and both are relatively clear. The contract is very clear that it does not cover prescriptions that are not on the formulary, and it in fact goes on to say, and it does not cover them even if they are medically necessary. I think the problem that you've identified here today in the questioning that preceded me is that plaintiffs conflate medical necessity with coverage, and that just can't be right. Otherwise, everything that is medically necessary becomes covered, and you don't need a contract, really. That's not what the statute says as well. The statute was, as the court has discussed, designed to implement a very narrow type of program, almost as an experiment to fill a gap for certain small employers that are at issue in this case. And in order to do that, it wasn't putting funds, the legislature wasn't funding it. It was being self-funded, presumably through premiums. And so in order to give some sort of basic coverage to small employers whose few employees might go uninsured, they wanted some basic coverage there. And they limited what that coverage is in order to get contractors to be willing to provide it. And they said, whatever you come up with your contract plan, that governs, and that's my reading of the second sentence in 2. It's your contract governs what benefits you're providing. And if they had wanted to include specific benefits legislatively, they would have said that. Interestingly enough, when you construe the statutory sections as a whole, because it's not just 12, it's 12.01, 02, 03, 04, and if you take a look at 3629-1203, it specifically says, any health benefit plan that offered by a contractor to persons defined as eligible pursuant to 3629-12 and that contains a prescription drug benefit shall cover amino acid-based formula that is ordered by a physician or registered nurse, and it goes on from there. So there's an indication there that the legislature knew when it wanted something covered in this basic plan, it knew how to do that, and it in fact enacted a statute to do that. We read the statute consistent with what you've discussed here, in that the first sentence really is about discrimination against an individual person based on their health status, and that just isn't the case here. The plan does not discriminate against anyone with Crohn's or colitis. It did not discriminate against Ms. Cancino. It simply limited the scope of coverage.
Well, there seems to be at least the implication in the opening brief that Ms. Cancino had in fact received Remicade earlier on different occasions, and I don't know if it was under the plan, but what does the record reflect with respect to that?
The record reflects, and by the record I mean at the administrative hearing with the notice of appeal, the appellant submitted some records. They are mostly hospital and doctor records. There is only one Mercy Healthcare record. They cover the years 2003, 2004, and then 2008 and 2009. And these records show that when she went into the hospital, when her doctor ordered her, either as an emergency or the doctor ordered her admission to the hospital, as part of her hospital treatment, she sometimes received Remicade. It was not pre-authorized by the plan because the contract doesn't require pre-authorization for hospitalization, drugs, and things like that. And in 2008, when the doctor began to try to start prescribing Remicade inpatient, out of the hospital as a prescription and receiving it in his office, let's say, for an infusion there, that's when the first denial occurred. The record reflects that in 2008, and they appealed. And the appeal was denied. It was untimely. So starting in 2008 on, the issue of whether or not she could receive a prescription as an outpatient for Remicade was very, very clear and was denied consistently. Certainly, the contract would have allowed our client to go back and examine that inpatient treatment and exclude retroactively or certain coverage, but it didn't do so for those 2003, 2004 treatments that were inpatient. So that is, to the best of my knowledge, what the record reflects. And in fact, the director's decision discusses the fact that there was, that the ALJ said that Mercy Healthcare had stipulated to the fact that she had been pre-authorized and received these. And the director's decision reflects, no, that's not what these records show. These records do not show Mercy Healthcare authorizing, pre-authorizing this. And once it realized what was going on here, that someone was trying to prescribe Remicade, then it denied coverage immediately. And again, we are here talking about an appeal that took place, an administrative appeal that took place for a specific denial in 2010. And I'd like to talk a little bit about the mootness issue, if I might, because it's our position that this appeal is in fact moot by the repeal of the statute. The plaintiffs claim that they have damages. I've looked through this record quite a bit. There is no allegation for damages or reimbursement. The first time I find the word reimbursement is in the conclusion of their reply brief here. The complaint does not make an allegation of damages, and the relief requested in the complaint does not.
Because at that time, the HCG program was still in existence. So you wouldn't necessarily expect her to say, oh, and I want reimbursement. What she wanted was prospective, at least prospective relief. And
I think the relief requested is in the nature of declaratory and injunctive, and it is prospective, and that is what she asked for. But this is an administrative proceeding, and the contract requires that you go through and exhaust your administrative remedies. And so if we can't tell whether someone has gone without or whether someone is expecting to be reimbursed, and when you're in that hearing, it is your obligation to put evidence in of what you are expecting your damages to be and to let the other side know that.
if we dismiss the appeal as moot, couldn't she bring a damage action or an ERISA-type action against Mercy Healthcare Group seeking to get reimbursed for her expenses?
I do not know ERISA law to be able to respond to that, but I do not think she could bring a damages action under this contract. This contract limits her remedy to going through a specific administrative process, and that is consistent with what I know about admin law.
But on the other hand, if we did not decided that the case was not moot and we affirmed, that would preclude, correct, any kind of damage. I mean, if we're saying, gee, it wasn't covered.
It would, and my client would welcome that, certainly. And mootness is a discretionary doctrine that this court may choose to use as it sees fit. We only wanted to point out that the statute has been repealed, that she has not really ever claimed damages here, nor did she put any evidence in of reimbursement, and therefore she has failed to exhaust her administrative remedy, abandonment, waiver doctrines, whatever doctrine you pick, because the contract requires that. And the funding, I will, in full candor to the court, say the only statute that hasn't been immediately repealed is the 01. They gave that a year. They gave it to the end of 2014.
That includes the fund, right?
Because it's the funding statute, and it's not in the record, but the public record of the governor's budget indicates what they're doing is they're finishing up administratively. It has to be some sort of funding to finish up claims and administrative functions. So, no, we think that the director's decision was correct, and you should affirm on that basis, and that the Superior Court's judgment in affirming was correct, and that the contract makes it very clear that this is basic limited coverage. It does it in the coverage provisions. It does it in the exclusions. It does it several times throughout the contract, in the handbook, in the formula. It's a fairly clear contract, and for an insurance, or it's not really an insurance, a health plan, contract in that way. And the discussions or the citations to medical necessity that the other side has cited to you have to do with covered services. We have to make a medical necessity determination for covered services. And in terms of a subset of individuals, I don't think the law requires us to parse down, because really what they're saying is, the worse I get, you can't limit the scope of coverage for everyone. Your cancer example was a good one. I may be, as a plan, give you coverage for certain things at a certain point in time, but not beyond a certain point in time. And really, there's nothing in the record. Remicade is her preferred, a TNF1 inhibitor is her preferred medication of choice. Maybe it's what her doctor believes is the most effective. But that's certainly, the record doesn't certainly reflect that they had looked at all sorts of alternative options.
Again, we don't need to get, if we affirmed on the basis that there wasn't a medical necessity provision, and there didn't have to be a medical necessity provision, we don't have to get into whether she proved this was a medical necessity. Is
You
that
are correct. It is simply a legal issue of whether the contract interpretation and statutory interpretation, and I believe the statutes, when read as a whole, confirm our position and the director's decision and the Superior Court's decision.
Ms. Casino's argument under subsection Q is basically that the plan is in fact discriminating against her based on the severity of her disease. And so this is not just simply a denial of coverage that would implicate the second sentence, but is really a discrimination based on the first sentence. How do you respond to that? What's your response?
I don't think that's correct. I don't think it has to do with the severity of the disease. It really isn't that Remicade is used for more. It's just a more effective treatment. There are a number of medications and treatments listed on here that may be effective. They just haven't been tried on her. She just wants this particular one. And again, I don't think the plan is obligated to provide absolutely everything that's medically necessary. Otherwise, a scope of coverage or you wouldn't need an exclusion. Basically, they're saying you can't exclude anything. The sicker I get, the more medically necessary it is, you can't have exclusions. You can't say, I'm going to take cost into effect and limit the scope of coverage for everyone who has Crohn's disease and only give this medication, these sorts of medications, as opposed to this one.
Your response is that the first sentence refers to discrimination on an individual basis?
Correct.
Okay.
I have nothing further. If the court has any questions, I would just simply ask you to affirm. Thank you very much.
Your Honors, in my very limited time, I'm going to respond as quickly as I can to several points. On the issue of mootness, the repeal of the statute on January 1st of this year was not a retroactive appeal. I think Your Honor hit the nail on the head that there was no way for Ms. Consino to know that this repeal was coming. She was seeking authorization of this going forward. Obviously, that didn't happen, so we're now looking retroactively. In terms of prior coverage, on pages 10 through 11 of the brief, MHCG had previously covered the provision of Medicaid, or excuse me, of this Remicade to our client before even the director's designee found that to be the case. The hospital listed at least 16 times in its
But that was
record
under
that
a
it was-
prior formulary, right? I mean, in 2010, or 2008 or 2010, the formulary changed and said, we're not going to be providing, and there are no exceptions. And there was an alert to that. I mean, there was in the record, there's the documents that alerted the patients that we're no longer going to be making exceptions. So even if it fell under some kind of exception, it no longer did.
That is correct, and while I'm out of time, I would just implore your honors to look at ARS 20-1057.02, which is the state of Arizona healthcare provision that basically says there has to be exceptions
How
to.
does that apply here? This is under Title 36.
Well, again, it was tough to tell whether MHCG was arguing that it was a state-private plan and was entitled to do as it pleased, or whether it was a state plan under 362912. So, as I'm sure you saw in the reply brief, trying to cover both bases because we're not sure what their position was. Thank you, Your Honor.
Thank you, counsel. Thank both counsel for their arguments. We will take this matter under advisement and issue a written decision in due course. With that, we stand adjourned.
Regardless of how the outcome comes, you won't have to fight this particular fight.
I think the program was an experiment. I don't think the experiment worked very well, for a variety of reasons that we can philosophically argue about.
Debate, sure.
But it's clear that the legislature said no more.